Hello everybody, my name's Andrew Gray and I'm the founder of Truth Legal Solicitors. Now today I'm going to go through the 14 things I think you really ought to do once you've lost your job, whether you've been fired, sacked, terminated, whatever it is you want to call it. Now, commiserations that this day has come to pass for you. It's a horrible day when it occurs. It's never happened to me, but I've guided lots of people through this process, and each time it happens, there's no way to make it really nice. It's a horrible experience, and I'm sorry that it has happened to you recently. But I'm here to help you to make the most of what is an awful situation, and I will go through now my list of 14 points I think you should follow to make the most of this tricky situation. The first thing, now don't shoot the messenger, but I think this is a moment to celebrate. Now that might sound perverse, silly, almost flippant from me, but I don't apologise for it. I said, having given lots of advice to these people in the shoes that you are in, I know that it doesn't feel like a time for celebration, but frankly it is, for these two reasons. If it is right that your employer got rid of you, perhaps you done something absolutely horrendous and you're worthy of being fired, well then, karma has occurred and you have lost your job and you were clearly in the wrong place because you wouldn't have done something so daft. Alternatively, and probably more likely whilst you're watching this video, is if you haven't done anything wrong and you found yourself having been fired, well, yes, how appalling for your employer to act in such a way. However, why would you want to work at an organisation that would fire you when you've done nothing wrong? So whether it's right you're fired or wrong that you're fired, either way it's a moment to celebrate. So if you like a tipple, have a tipple. If you do something else to celebrate, do that thing. This is a moment to clear your mind and prepare for the next stage in your life. Now the second thing that I would do if I found myself in your shoes is, I know this sounds a bit airy-fairy, wishy-washy liberal, is to meditate on your situation. If possible, go away from the expectation of family and friends. It might be to another country, come to the countryside, someone else is at home, just if you can, away. Now you might have responsibilities, caring responsibilities and parental responsibilities and so on, but as much as you can, I think you need some deep thinking time to work out what your values are if you're not sure what they are. Because frankly, if you're going to work at an organisation, you need to ensure that your values and their values are aligned. Usually people find themselves watching videos like this because their values with their former employer were misaligned, and it's come to a head where there's been a clash and you've gone, either rightfully, wrongfully, but whatever's happened, there has been a clash of values usually. And I suggest that in your next stage of your life, that your values and your work are intertwined, that there is no differences between the two of you. So whilst you're away in this at least mental space, perhaps even a new physical space, another country, work on not just your values, but what do you want in the short term? What is it you want in the medium term? And of course, what is it you want in the long term? Now is an opportunity perhaps to retrain to another area. It could be to go back to studies, perhaps. It might be a time to have children, or it might be a time to become a carer or a charity worker, or a time for a sabbatical, a long holiday, backpacking. Write a book. I don't know what it is, but this is an opportunity that has been gifted to you, and you can opt to do something positive with it. Now the third thing that I would do if I was in your shoes is, this is an obvious one, just reduce your spending. Unless you're a multi-billionaire, and you're probably not, and I am not, you need to cut your cloth accordingly. I know these days times are tough for a vast majority of people living in this country, but if you can, it would be best if you can put together 3 months of sort of savings, so that it covers your rent or your mortgage and the key bills. If you've got 3 months of that, you're going to find this period of time much more relaxing. It means that you're unlikely to take your next job, which is going to be unpleasant. It gives you a chance perhaps to have a holiday or a break, which might seem counterintuitive when you've got no money coming in. But this is a moment to cut your cloth, save some money, because listen, we all know that we're going to have subscriptions that we probably shouldn't have. There's this Netflix or an Amazon Prime, whatever, that can just be got rid of. Now they're granted small sums, but you can make some pretty decent savings if you apply your mind to it. It will be a little bit painful, but You won't miss them after a week or so, I promise. Now the fourth thing that I would do if I found myself in your shoes would be to compile a list of everything that has happened which has put you into this situation. So all the conversations that you've had at work, can you write them down now? Who said what, when? Can you remember the emails? In fact, do you have copies of those emails? To try and put things in a chronological order when things started to go wrong. Put them all down in a nice way, either put them on a notepad written down, or more likely save them to your phone, even have some voice memos if you want. Whilst it's fresh in your mind, commit it to paper or to put it in the cloud somewhere. Few reasons for it. It allows you to understand perhaps what's happened. If you can trace from the first incident to actually being fired, it will be useful for you to understand how you found yourself in this situation. But also, if you were going to bring a claim to an employment tribunal to engage employment lawyers like we have at Truth Legal, what we would want, in fact any lawyer would want, is to see someone who's organised, who's got a grip of the paperwork, and that can provide the paperwork to us in an efficient, orderly way. Now, if you bring a claim yourself to a tribunal as a litigant in person, that is without a lawyer, a court will want to see, or tribunal will want to see, that you are acting in a organised, fair, systematic way. Lawyers like it, judges like it, opponents respect it, and if you need to deal with the ACAS, which is a conciliation service, they'll be asking you questions about who said what, when, who was it, etc. Now, when you are speaking to perhaps ACAS, or you're speaking to your employer in a grievance situation, appeal situation, write down what they tell you. Take contemporaneous notes of it. You know, you had a phone call from Tim, Donna on these dates, this is what they said. Make a note of it, because those contemporaneous records can be really useful down the line. Now, the fifth thing I would do if I was in your shoes is, now is the time to look for a new job, or this is the time to go back to studies or to start a new business. All those things are quite daunting, granted, but this is the time to do it. When you're looking for work or thinking about setting up your business, you need to keep screenshots on your computer or smartphone as to the efforts that you've gone into to look for work. The reason for this is if you do choose to bring an employment tribunal claim, you've got evidence to show to the court, tribunal, or to the other side that you're making efforts to find alternative work, so that they can see what's out there and the efforts that you've made. So also, when you're talking to recruiters, keep a record of those emails, those conversations. Great thing to do. It's called mitigation, reducing your losses, making the best of a bad situation that you'll find yourself in. So do it systematically, do it regularly, do it frequently, and look for the correct jobs. You know, if you were at a particular level, it's fair to look for that level. I perhaps suggest not looking for jobs above that level. If you're thinking about opening a business, you know, think about the bank, think about your business plan, maybe a business coach, funding, all those sorts of things. Keep a record of it, that you are someone who's organised and is trying to make the best of this awful situation that you're in. The court want to see it, everyone want to see it, and frankly, it might just lead you down a fantastic opportunity. And that takes you back to the first thing I said was, this is a moment to celebrate. This is the start of the next phase in your life. Now, the sixth thing that I would do if I was in your position is to make what's called a subject access request. Now, under the General Data Protection Regulations, GDPR, or formerly known as the Data Protection Act 1998, essentially you can ask any organisation that has information about you, well, you can ask for that personal data. They are data controllers, you are data subject, and you can ask for it. For example, you could ask the council for any information that they have about you, for example, what council tax you paid. But here I'm suggesting that you need to use it with your former employer. So you write to your employer and you say, I would like all the information that they hold on you. You can ask for any emails that they have, your occupational health file, any WhatsApp messages, text messages between directors and managers. Everything that they have, they should give to you, unless there are things which they shouldn't. For example, if they're talking to their lawyers, or they're protecting themselves in advance of any sort of litigation, any claims that you might bring. But more or less, under the General Data Protection Regulations, they must provide you that information within 40 days at no charge to you. Now, once you've got this information, again, you need to go through it in a forensic way, like a policeman would, or a lawyer would, or a judge would. Work out what were the key moments. It could be in this treasure trove of information that you now have. You can see why it is that you're here watching a video about what to do when you've been fired. It could be that something discriminatory has occurred. It could be that you told your manager that you're pregnant and you found yourself out of work, being made redundant. And you've always wondered what it was, and there it is. There's an email between a manager and another manager saying that you're pregnant and they want to get rid of you. Or whatever it could be. There's some amazing information that can come out of a subject access request. It's not an unpleasant thing to do, perhaps might seem a little bit of an aggressive thing to do, but it's certainly a right that you have to make. And I know that law firms such as Truth Legal would think very highly of you if you're coming to us with a treasure trove of information, and we can assess your case to take it through to the next stage if needed. Now, the seventh thing that I would do if I was in your position is to consider whether or not you need to submit a grievance. Now, even though you've been dismissed, you can still submit a grievance. Some employers may not want to deal with the grievance once you've gone, but they probably ought to. Now, I'm not in any way recommending that you submit a dodgy grievance, a grievance just to make a pain of yourselves. I'm not suggesting that at all. If you genuinely harbour some ill will because of some situation that has occurred at work, however long ago that was, you should consider the grievance process. It could be that by submitting this grievance, your employer looks at the whole situation again, either you and reinstates you. It could be that they realise that you ain't going to go away easily. Perhaps you've done a subject access request and now a grievance comes and they think, well, potentially we need to offer some sort of settlement to smooth your departure so that a claim does not come. And it could be as well in you raising this grievance, other managers looking at the situation and they might realise how much trouble that they're in. Again, a settlement might come your way. But either way, when you're producing a grievance, or when you're delivering a grievance, it generates paperwork. Not only you sending paperwork to them, but there'll be some internal wranglings as well, and perhaps even a hearing where you can put across your best case. But to repeat, I do not recommend in any way you submitting a grievance if you don't have a legitimate reason for making a grievance. Now, the eighth thing that I would do if I was in your shoes, and notice this is the eighth thing and not the first thing, it's very deliberate. The eighth thing I would do is to consider, not necessarily to, but to consider whether you should make an appeal against the decision to fire you. Let me explain. If your employer was wrong to get rid of you, perhaps they followed the wrong process, or just the whole decision-making thing was wrong, then by appealing, likelihood is that they're going to have people of a higher calibre on it, perhaps they're even their lawyers on it looking at the situation. And it could be that the reason they fired you for wasn't a very good reason, but there was another reason that they could have got you for. And therefore by appealing, you bring it to their attention, and therefore they can right some of the wrongs that they have done. Now, of course, you can appeal and get your job back, which often would be fabulous. But if you appeal and they right their wrongs and still fire you, it puts you in a more difficult situation. That's why you should be exercise caution by appealing. But if you don't appeal, and you perhaps should have appealed, if you win your employment tribunal claim down the line, the tribunal might say, well, why didn't you appeal? And they might penalise you by up to a quarter of the value, more or less, of all of your claim. So you can get kicked by a quarter of the value of your claim by not appealing. Therefore, this is something to weigh up. It might be that you prefer the chances of winning without having appealed and take the loss of a quarter. I don't know, this is a matter to weigh up carefully. However, if you do appeal and your employer still decides to uphold the decision to get rid of you, and again that they shouldn't have done and it was unlawful, the employment tribunal will say, well, you tried everything, Mr. or Mrs. Employee, we are going to increase the value of your claim by a quarter. So in this situation, by appealing and your employer still terminating you, the value of your claim has gone up by a quarter. And in a way, it increases your bargaining position. You put them through more difficulty with an appeal and also potentially inflated the value of your claim by up to a quarter. I would add as well to that, you must be very careful that you stop the clock. When you've been fired, all the time limits more or less run from that date, from the effective date of termination. If you appeal, on most employees, very logically, understandably, they think that the clock has stopped from bringing a claim, but it hasn't. So yes, you can appeal, but if the clock is ticking, you need to trigger ACAS early conciliation, and to do so quickly. You can go to the ACAS website or go to the Truth Legal website and follow the links through, and you can freeze the clock, because you've got 3 months, less 1 day, really, to do anything about the situation if you want to bring it to an employment tribunal. Also, by appealing, you're generating more paperwork, more reasons as to what's gone on. And paperwork is something that is useful for tribunals, but lawyers like us, we like paperwork. So seeing the appeal process, the rationale, the emails is all very helpful to your case. So when thinking about appealing, I strongly recommend that you get independent and brilliant employment law advice, because it might be the wrong thing to appeal, it might be the wrong thing not to appeal. It isn't that very typical lawyer thing to say, but that frankly is it. Now, the 9th thing I would do in your position is to check whether or not you've got legal expenses insurance, LEI. Now, I've only got a minute to explain it. There's a lot more information on the Truth Legal website. If you go into the search function on the right side and type in legal expenses insurance, I will explain it. And this is absolutely crucial, game-changing to your bargaining position. Now then, legal expenses insurance is insurance which is often tagged on to other insurance, usually home insurance, particularly buildings cover, but sometimes contents cover. So if you live in a house, flat, whatever, when you're in the situation of having lost your job, you need to work out how would you potentially pay for any legal fees. Now, if you live in a property that does have legal expense insurance, even if it was your mum and dad or the landlord that's got it, it could be that you're covered under that policy. You really need to check. Now, most legal expenses insurance policies have either £50,000 to £100,000 legal cover. That is a hell of a lot of legal cover that you might have. It might be, in a way, if you do bring a claim with legal expense insurance, you have greater legal firepower than the employer has. The tables can be turned by having legal expenses insurance. So a lot of people don't know that they have it. When they're buying insurance online, it's compare the market or whatever money supermarkets there are. If you tick a little button, or even if you haven't, it could be that you've got this policy and it could only cost £20 or £30 a year. But I strongly recommend that you check home insurance. Occasionally it's on car insurance, that's usually about car accidents, but sometimes not. Often on credit card insurance, and it could be maybe on travel insurance. We've got all sorts of things. But home insurance is the key one to check. Now, if you do have legal expenses insurance, you need to ring them up and explain to them what's happened to you and see whether or not you've got cover. Now, if you've got cover, it could be that you go to speak to the insurers direct and explain the situation, and they might back your claim. It might be that they send your claim to their panel solicitors, they're sort of their friendly lawyers that they have, for them to assess the claim. By assessing the claim, what I mean is they're checking whether or not you've got over a 51% chance of winning your case, more or less, and that the claim has some value. They'll be checking those two things. Now, can you use lawyers like Truth Legal under your legal expense insurance? The answer is yes, and we've acted under most legal expenses insurance in the country. It's not always that easy for us to act under someone's legal expense insurance, but we very much try. Now, if you do bring an employment tribunal claim and it's issued as a tribunal, you've got what's called freedom of choice to appoint any solicitors you like. So it might be that the panel solicitors have been instructed to start off with to represent you, but it could be that you want to flip to a firm like Truth Legal, to switch solicitors to us, perhaps for a better service, to guarantee that you get a solicitor, all of those reasons. Or will you have the benefit of this legal expenses insurance? Now, it is quite tricky. The insurers, I don't think, always make it easy for you to access them. Sometimes you need to complain to the Ombudsman if they are not backing your claim, or they won't let you use your solicitors of choice. Now, in some situations, if they won't let, say, Truth Legal act under the policy, there could be exceptional reasons why you need to use us. It could be that you've already paid us some money. It could be that we've already spent hours looking after you. It could be that we've got a specialism. It could be that we're close nearby to you, or that we speak language that you speak. So you can argue with your insurers and say, there are exceptional circumstances why I want to use Truth Legal or another firm of lawyers. It is your insurance, you've paid for it, and I think in theory you should be able to take it to whichever law firm that you want to enforce your hard-earned legal rights. Now, the 10th thing that I would do, which flows very nicely from the 9th, is take very specialist employment law advice. Now, me as a litigation lawyer who does employment law, personal injury law, property litigation, I'm a litigator. I only have a niche area of law that I specialise in, and that's very true for most solicitors. The days of the generalist solicitor that would do your wills, that would do your divorce and your speeding tickets and all that sort of stuff are more or less long gone. So do not think for a moment, just because someone is a solicitor, a paralegal, legal executive, whatever it be, that they will automatically know everything there is to know about employment law. The chances are that they won't. So whoever you instruct, ensure that they are specialists in your particular area. And if it's a discrimination claim that you have or whistleblowing, ensure that that employment lawyer has knowledge of whistleblowing and discrimination law, because it's quite different from more simple wrongful dismissal and unfair dismissal law. So, in essence, ensure you're speaking to a specialist. Now, the 11th thing I would do if I was in your shoes, and this is only really relevant if you were a senior person in the organisation that you've left, is to check any restrictions that you have, any post-termination restrictions, where it is that you can work next, which customers that you can work with, any clients you can take with you, any staff that you can take with you. If you have tight restrictive covenants which are enforceable after termination, you really need advice as to what it is you can and can't do, because you might find yourself on the wrong end of a very expensive injunction, which is something to be avoided at all costs. I should also say that a lot of employers put restrictive covenants into contracts, knowing full well that they're not enforceable, that if you went to a court over it, that you'd win. But they often do it to scare you, to stop you making an action, taking a client, setting up here, whatever it is that you're going to do. Employers can do it to scare you, knowing that perhaps they've got more money than you've got, more firepower, more time, and that they can absolutely take you out of the market. But if you are bound by restrictive covenants, or think you are, you need to know whether or not those restrictive covenants are enforceable. Now, the 12th thing I would do in your position, this one is crucial, is to trigger ACAS, early conciliation, at the right time. What is ACAS? Well, ACAS is a conciliation service. It's a neutral organisation paid for by the government. They are run by ACAS early conciliation officers, who are very capable people that are used to resolving workplace disputes. Now, if you've been dismissed, you've got 3 months less 1 day to start ACAS early conciliation, otherwise you're out of time. But also if you've suffered a discriminatory incident at work, you have 3 months to start ACAS early conciliation. Now, it's quite tricky, and I don't propose going into more detail about it now, but do know, as I said earlier, that if you are appealing, the ACAS clock hasn't started yet, you need to freeze it. ACAS legislation can last for up to 6 weeks. And if you want to bring an employment tribunal claim, you must have at least attempted to settle. So started ACAS legislation, got a certificate to prove that you've tried negotiating. Even if you almost had no intention of negotiating, you need to have that certificate on your ET1 to show that you have tried resolving it fairly, because the whole purpose of ACAS legislation is to resolve workplace issues before they go to an employment tribunal. So start it. For more information, go to the ACAS website, ACAS, or go to the Truth Legal website and look for ACAS early conciliation. Now, the 13th thing you should consider doing is bringing an employment tribunal claim or a county court claim. As I said earlier, you need to have an ACAS early conciliation certificate to start an employment tribunal claim, not so for county court, which sees far fewer employment claims, and they're usually contractual matters only. Again, take specialist legal advice for bringing an employment claim. If you're going to do it yourself, have a look at the Truth Legal legal library. We've got some great documents on there, give you an idea as to the sort of things you need to write in your employment tribunal claim. To do so, you need to fill in an ET1 form, and you need to really put together all sort of grounds of claim, explaining in a chronological, organised way what's happened to you, where the breaches of the law were, and what remedy, sort of what you want. So think about the employment tribunal claim. County court claim, perhaps, is a complicated thing to go through, but a lot of people do it without a lawyer or without a trade union officer. You can do it yourself. It is hard. Probably best to do it with a lawyer, but I suppose it depends on whether you get a no-win, no-fee agreement, like what we offer, legal expenses insurance, which we offer, or sort of lower fixed fees, affordable rates, etc. But if all those things are impossible for you to obtain, do bring the claim and ensure that you bring the employment tribunal claim as quickly as possible once ACAS early conciliation has finished. The law is quite complicated as to when you should or shouldn't bring that claim, but my advice is as soon as ACAS legislation is finished, really within that first month, if not sooner, you should bring that claim so that there are no arguments that you were out of time bringing your employment tribunal claim. Now, we're nearly there, ladies and gentlemen. The 14th thing you could consider doing is to bring a second subject access request under the General Data Protection Regulations, GDPR. Now, you perhaps have already made the first one, or maybe not, but now we're at a stage where maybe you've appealed, more information's occurred, maybe there's been some chatter about you in the office by email, by WhatsApp after you've left, and you're at a stage now where you can make a second subject access request, or this could be your first. This could obtain, again, another treasure trove of information as to why you found yourself fired watching videos on the internet like this one. Again, they're free to do. You're not supposed to really make that many of them. You're not supposed to be a pain in the neck in making these subject access requests. If your former employer has not adhered to it, hasn't sent you the information within 40 days, then you can complain to the Information Commissioner's Office, ico.gov.uk, which polices sexual data regulations in the UK. And if your employer has been intransigent, it might be that they get hit with a fine by the Information Commissioner's Office. It could also be that there's a separate standalone county court claim that you could bring against them for failing to comply with GDPR. Finally, ladies and gentlemen, we've done the 14 points. Thank you for bearing with me. I hope you've learned something. I hope you've chilled out a little bit. I hope you've got your mind organised. I hope you've worked out whether or not you've got legal expenses insurance. It could be that there's a firm out there like Truth Legal that can offer no fee agreement to bring your case. I say to you, finally, as a thought, just work out how much time and mental energy you want to commit to any sort of action. They are disrupting to your life. However, people that do go through the process, they learn a lot about themselves, they learn a lot about law, and I think they gain a lot of confidence, even if they've lost a case. Talking to lawyers, going to tribunals, giving witness statements, all these things seem a little bit, well, actually, frankly, quite scary. But to go through the process, sometimes, again, doing it on your own without a lawyer is a moment where you can grow up, to mature, to know how to enforce your rights, to understand legal terminology, realise it isn't actually that scary when you've gone through it. There are incredible learning opportunities for you, but they are so time-sapping our employment claims. I mean, how many minutes have you watched already this video? And how many more minutes do you need to watch other videos and so on? There's so much time that needs to go into something like this that you should only enter claims if you're really committed to the cause, if you're particularly angry about it, or there's compensation waiting for you. Perhaps you've got nothing else it is that you want to do. Or it is that you want to be that martyr. You want to show your former employees that you did nothing wrong. Maybe you want to show up your employer for their poor behaviour. I don't know. But whatever it is, I ask you to bear in mind how much time, emotional energy that you'd have to put in to bringing a claim. If you want to talk to our lawyers here at Truth Legal, email us at inquiries@truthlegal.com or go on our website, book an appointment. It's a free 15 minutes. Delighted to help you. Sorry you're in this situation, but I really hope that everything is an upwards trajectory from now on for you. Thank you.